Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to talk about a motion that you can file with the court if you are stuck in a situation where the opposing party, normally your ex, is just filing motion after motion after motion, all of which are motions that have no merit to them. They're basically just, wasting court time or causing you to spend money on attorney's fees, etc. So I'm going to start talking about this by showing you an appellate court case. So this is a case, it's called Strobel v. Strobel. It is from back in 2005, and I will read some highlights from it that explain what the case is all about. So on June 25th, 2003, the trial court, Avery Whetstone, that's the judge, wrote in regard to this case, "This is a tragic case of a child torn asunder by his parents' never-ending divorce battle that began 8 years ago. The sheer volume of the pleadings filed by the parties is astounding." And then the judge goes on to talk about the many motions, over 100 motions that each party had filed. Then the appellate court says, finding that many of the motions filed in this matter were overabundant and ceaseless and often duplicative, redundant, and without merit, and in an effort to bring some sanity to this extraordinary situation, Judge Avery Whetstone issued the following order. Neither parent shall file any motions or pleadings without prior approval of the court. If any motions are filed, they shall be filed in Bridgeport. The presiding judge for family matters in the Fairfield Judicial District shall review any motions filed by either parent and determine if the motion is redundant, vexatious, frivolous, or an abuse of the court system or the minor child. If the presiding family judge determines that the motion merits a hearing, it shall be forwarded to the regional family trial docket for scheduling and hearing. So the judge basically said nobody can file any motions without permission from the court first. And if the court finds that the motions are redundant, vexatious, frivolous, or an abuse of the court system or the minor child, the court will just deny the motion on the papers without anybody having to go to court or do anything. They'll just deny the motion. So this was a controversial ruling. It hadn't been done in the past, but ultimately the appellate court, which is the higher court, they found that this policy was acceptable. So the appellate court said, our review of the record reflects the sad accuracy of Judge Avery Whetstone's observation that the parties herein have filed barrages of repetitive and abusive motions in an apparently ceaseless war of hostility and vindictiveness towards one another, and that those motions are not only abusive to the system, more importantly, to their now teenage son. The court's efforts to limit the battle are praiseworthy. In denying the parties' motion, the court's findings were clearly supported by the record and well within their discretion. So I will show you a sample motion if you want to try to get the court to enter a similar order that the opposing party cannot file any motions without the court's permission. So here's the sample motion. This will be on our website. Just search in the video section if you want to download a copy of this motion. So it just says that pursuant to the Connecticut practice books and Strobel v. Strobel, which is the case I just showed you, the defendant respectfully moves this court to enter an order imposing restrictions on the plaintiff's ability to file any further motions without prior approval from the presiding judge of family court for the Judicial District of New Haven at New Haven. In support thereof, the defendant represents as follows. So give the case. So pursuant to Strobel v. Strobel, the court has discretion to enter orders requiring approval from the presiding judge before a party may file future motions. And then in the above captioned matter, so in this matter, and then you're going to want to insert details, including the history of the case, so how many motions have been filed, actions that have been taken by the opposing party. You want to present evidence of how the opposing party's motions are overabundant, ceaseless, duplicative, and or redundant, and are without merit. That is the key part, that they are without merit. And you may want to use some of the language from the appellate court case or the underlying case in the Strobels, showing that the motions are redundant, vexatious, frivolous, or an abuse of the court system or the minor child. So back to the motion, you're going to want to insert all of those details and then, ask for the relief that you're seeking is in order that the plaintiff must file a request for leave to file with the presiding judge prior to filing any additional motions in this matter. So it's basically saying you want the opposing party to have to ask for the court's permission to file any other motions. So if you file this motion, it will be scheduled with the court. Presumably you'll file this, while there are other motions pending, presumably your ex's ridiculous motions. And then, you'll get into court and a judge, you can make an argument as to why you think your relief that you are requesting, that the other side need permission from the court to file motions, why that should be granted. And you'll give the history of the case, and then hopefully the judge will grant your request if they find that, it's a good request and it should be entered in order to protect you or the court's time or your child, etc. So those are the basics on what you can do in order to try to slow down, litigation if it is sort of ridiculous and relentless from your ex-spouse. As usual, if you have any questions, I would invite you to contact our office. And if you are looking for representation in a divorce or family law case, we would invite you to contact our office as well.